The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. This is Tricia Teofilo Olave, and I'm here today with Hillary Richardson, and we're going to be talking to you about working with survivors of domestic and gender violence. Thank you for joining us. Let's see. Oh, there we go. So the National Immigrant Justice Center, as you all probably know, is a program of Heartland Alliance, and we do a lot of service to immigrants, refugees, and asylees through a combination of our direct legal services, and we also do policy reform, impact litigation, and education into the community. We have a huge network of pro bono attorneys. Thank you to all of you who are pro bono attorneys out there. We are able to serve more than 10,000 immigrants on an annual basis because of our large network of over 1,500 pro bono attorneys. So thanks to all of you, we're able to reach many more immigrants, and we have a 90% success rate in representing asylum seekers and immigrant survivors of domestic violence. We represent clients from all over the world, over 95 different countries, and all of our clients qualify for our services because they're at or below 200% of the federal poverty guidelines. So we can screen for clients at any income, but if they are above that, we will refer them out. So we're going to get into our webinar right away. I'm going to turn things over to Hillary.
Hi, good morning, everyone. So I'm just going to talk a little bit about a couple of forms of relief where you might encounter clients who've experienced domestic or gender-based violence. So we've got a whole list here. Really, domestic and gender-based violence can appear in any type of case, in any type of situation. But we're just going to briefly go over some particular type of cases where that may be common. And it's common mainly in our protection-based cases. So cases where you're likely to see clients who've experienced this type of violence would be asylum, special immigrant juvenile status, T visas, U visas, VAWA cases, and then in general, if you're serving LGBTQ individuals who might be eligible for any type of relief, that's also a client population where this is something to be aware of. So Tricia and I are just going to go over a very brief overview of each of these types of relief, just so that we're all kind of on the same page. And then what we're really going to focus the main part of our presentation on is some specific tips and best practices for working with those survivors. So asylum, as many of you may be aware, is a protection-based claim to relief from removal from the United States. An individual is eligible for asylum if they can show that they meet the definition of a refugee. And that definition is codified in the INA, in the Immigration and Nationality Act, at the site above that's listed here in the presentation. But it's basically anyone who is afraid of persecution in their home country based on one of 5 protected grounds, and that's race, religion, nationality, membership in a particular social group, or political opinion. It's one of the more complicated forms of relief, and there's a great deal of case law and guidance on the definitions of those groups and the definitions of persecution. But these are individuals who have suffered or who fear persecution based on one of these protected grounds. And domestic and gender-based violence are frequently components of some of those types of persecution that those individuals see. So for example, common asylum claims that we see might be based on things like child abuse, gender-based violence generally, gang recruitment, and many other types of situations that our clients encounter. Special immigrant juvenile status is a form of relief specific to children or to minors. It's available to immigrant children who've been abused or neglected or abandoned by one or both of their parents. It enables that child to eventually get permanent residency or a green card in the United States and be on a path to citizenship. And it's available for both accompanied and unaccompanied children. So that's just that refers to the definition of unaccompanied immigrant child, which refers to how the child entered the country. So as you may have heard, there are many children who have entered the country without one or both of their parents, but there's also children who've entered the country in the company of one or both of their parents. And this form of relief is available to both of them the main basis for the case is to show that they have suffered this abuse or abandonment or neglect. The basic requirements for SIJS are laid out here. The child has to be 21 years of age and unmarried. They have to be present in the United States, so this isn't like a visa that you can apply for from abroad. And then the tricky part of the SIJS case is that before they can submit their immigration application, they have to go before a state juvenile court in order to get that court to make the findings regarding the abuse or the abandonment or the neglect. And so here at NIGC, we have a project that works specifically on that type of case and places those cases with pro bono attorneys in order to obtain those state court predicate orders to allow these children to apply for this type of relief.
VAWA cases are part of the Violence Against Women Act, and it's not specific to women. Women, men, and children can all qualify under VAWA. And the VAWA law was developed to protect victims of domestic violence who would otherwise qualify for relief through family-based immigration. So typically, a petitioner who is a U.S. citizen or a permanent resident would petition for their family members, but in some circumstances, this is not happening because the petitioner is abusive. And so who can qualify for VAWA? Well, it would be an abused spouse of a U.S. citizen or permanent resident, an abused child of a U.S. citizen or permanent resident, or an abused parent of a U.S. citizen child. And that's because those are all categories of individuals who would otherwise qualify for family-based petitions in immigration law. In order to be eligible under the Violence Against Women Act, you have to prove the good faith marriage, if that is, if the case is based on marriage. You also have to show joint residence. You must prove that you're a person of good moral character during the statutory period of 3 years. And you have to prove that you have suffered battery or extreme mental cruelty, and those are also codified. And then there is actually a definition of battery or extreme cruelty that can be found in the Code of Federal Regulations at section 204.2. And just a couple of things to note, that no single factor is a prerequisite. In fact, they'll look at the totality of circumstances in a case, because oftentimes when you're talking about domestic violence, there might be many instances that lead up to a person leaving an abuser. And so maybe there wasn't one huge explosion of violence, but there were many incidences that involved domestic violence. And then another thing to note is that it doesn't have to be physical abuse. It can also be extreme mental cruelty. So we often are looking at psychological abuse, sexual abuse, forced prostitution, and other kinds of abuse. The T visa is a visa specifically for victims of trafficking. And so usually we're talking about sex trafficking or labor trafficking. The individual must prove that they are physically present in the U.S. on account of the trafficking. They have complied with any reasonable request for assistance in an investigation or prosecution, or they can be under the age of 18. And they have to prove that they would suffer extreme hardship involving unusual and severe harm upon removal. So there's a definition of the victim of trafficking, and that would, as I mentioned, include persons who are victims of sex trafficking, also labor or services, and it defines in here the various things that need to be proven. And U visas are for victims of crime. So it's not just any crime, but there is actually a list of crimes that can make a person eligible for a U visa. And then in order to be eligible, you have to prove that you have suffered substantial physical or mental abuse as a result of being a victim of the qualifying criminal activity. You have to prove that you have information concerning the crime and that you have either been helpful in the past, you are being helpful, or are likely to be helpful in either the investigation or prosecution of that criminal activity. And finally, that the criminal activity violated the laws of the United States or occurred in the United States. So again, what is substantial physical or mental abuse? In the U visa context, it's in the Code of Federal Regulations at 214.14, and they talk about the nature or injury inflicted or suffered and the severity of the perpetrator's conduct, severity of the harm suffered, and the duration of the infliction of the harm, and the extent to which there is physical or mental soundness of the victim, including aggravated or pre-existing conditions. And so they're going to look at, again, the totality of the circumstances and not just any single factor being a prerequisite to establish the abuse suffered. So we want to go into some of the barriers and challenges that survivors of domestic violence and gender-based abuse suffer. And we've talked now very briefly about some of the forms of relief that will apply, but it is important that if you're working on these cases, you understand these barriers and you can look at these cases in a unique light, okay? So for example, many of our clients, due to the fact that they're immigrants, speak different languages and have limitations due to that. But when you're talking about victims of crime or domestic violence, oftentimes they have difficulty in doing something as simple as filing a police report. So if you're a victim of domestic violence and you call the police and the police officers don't speak your language but the abuser does, then oftentimes the police report contains information that is not true or is skewed in favor of the abuser rather than in favor of the victim. Also, many of these clients will face extreme isolation. So oftentimes the abuser will sort of isolate the victim and prevent them from spending time with family. Maybe they don't have any family nearby, or they don't have access to a phone or a means to contact people. Many times there are cultural ideas of abuse that play into whether or not someone identifies themselves as a victim of domestic violence. And also the ideas of family shame and honor. In many cultures, it is determined that this should be something that's only discussed within the family and it shouldn't be brought out in public. And people feel like because of that, this is something that they have to deal with in private. They're not allowed to discuss it. It's not considered something that they can seek help for. And oftentimes people don't even know that it is a crime or against the law. Again, dealing with very close-knit immigrant communities sometimes can be a challenge too. If the people that you know and trust in your support network are all part of your immigrant community, and then they tell you that you have to stay with your abuser, or you have to try to work it out, or it would be a shame for you to report this to the police because it would affect somebody else in their community, then oftentimes that guilt and burden is another barrier that victims are facing. And then finally here we have listed the role of religion. And you know, for some people, religion is of utmost importance, and the idea of divorce or even separating from an abusive spouse might be something that they consider to be against their religion. Or they might have religious advisors or people of authority telling them that they need to stay in an abusive relationship. So these are all things that, regardless of your personal views, you need to take into consideration when dealing with clients who are victims of domestic violence and gender-based violence, because oftentimes your client is coming at this with a very different perspective than what you have. And when they're living in this scenario, it's very difficult to see things from an outside perspective. And oftentimes they're so overwhelmed with the abuse and the other challenges that they're facing that they can't see how they can get out of the situation. So it's helpful then, as somebody who's trying to work on their legal case, for us to understand some of the tactics that are used by abusers. So how does somebody even get into a situation like this? Well, if you look at this wheel, this is called the control and power wheel. And this is very common. It's utilized in domestic violence circles by advocates, and it's often utilized in counseling. So we recommend that our clients go to counseling to seek therapy, and it can often help them understand and recognize that they have been a victim of abuse. Many of the clients, as I mentioned, don't even recognize that some of the things they have been subjected to are against the law or that they're problematic. And so helping them by going to counseling and helping them to recognize the power and control can get them to a place where they're willing to see that things can change, right? Sometimes if you have grown up in an abusive environment, you think that this is just the way that things are and that there's no hope for things to ever change. So I want you to take a look at some of the things surrounding the wheel. Isolation, which we already talked about. Also intimidation, that is very common, especially with immigrant victims, because being intimidated by their abuser that they could be deported or have their children taken away is a very, very serious threat. And then, of course, we talk about threats. Physical abuse is usually the most common. That's what people automatically think about when they think about domestic violence. But there are many other kinds of abuse, such as sexual abuse, economic abuse, and emotional abuse. Some examples of all of these. So sexual abuse can be marital rape, which in many cultures people don't realize that that is even a thing. You know, if you're a victim of rape, just because you're married doesn't make it okay. So sexual abuse can also include name calling, calling somebody a prostitute, or alleging that somebody has a history of prostitution on their legal papers. Economic abuse can be not allowing the individual to work or withholding money. This is often common in the marital relationships where one person controls all the money. Maybe the immigrant victim doesn't have authorization to work and is afraid to work, or doesn't have an education and is being told, you know, you have to stay with me because who's going to provide for you and the children. Emotional abuse is very common, and it's oftentimes very difficult to recognize, but it can start with things like name calling or forcing the client into a state where they sort of have no sense of self-confidence and self-esteem, lowering their self-esteem to the point where they feel like they're worthless. And then oftentimes that is multiplied by the physical and verbal abuse, where the person actually starts to believe that they're worthless and that they can't possibly make anything of their life. Citizenship or residency privilege comes into play when the abuser will refuse to file papers for someone, so using that as a way to control the situation, okay, not allowing the other person to get legal status and keeping them in a subservient situation. Isolation, as I mentioned, can be isolating them from friends and family. Intimidation would be things such as hiding and destroying important papers, destroying the person's property, putting them in a position where they're afraid of the abuser. And then threats, threatening to report the victim to immigration, to have them deported, as we've seen in the news in recent months, where victims are oftentimes afraid to even get an order of protection because they might be subject to deportation if they go to the court. So these threats are very, very real for our clients. And especially in the current environment, we have to understand that nothing is easy for immigrants who are trying to get out of an abusive situation and make their lives better. Next, I want to speak a little bit about the cycle of abuse, because oftentimes on the outside, as the person who is trying to help the client, we can easily identify that they have been a victim of abuse, and the client might easily identify that they have been a victim of abuse. Or maybe it wasn't easy, but they've come to the point where they now recognize this is an unhealthy environment, and they want to get out of it. But oftentimes, the cycle of abuse is such that a victim continues to return to the abuser. And why? Well, first of all, you see that denial is at the center of this circle. Okay, so denial is necessary for this cycle to continue. And things start oftentimes perfect, right? You have a honeymoon phase where everything seems perfect, and then tension builds, and then there's an explosion. So we see this in many different ways. So an abuser might initially seem like the perfect gentleman. Maybe things started out where he was actually sort of a form of escape from a prior abusive relationship, whether it was the home environment growing up was abusive, or maybe a previous partner was abusive, but then this knight in shining armor comes along and things seem perfect, and he seems to be like the perfect way to escape another bad situation. But then the tension builds, and that can start very small and seem innocent. Sometimes it's involved with drugs or alcohol, and so it's easier for the abuser to blame it on something else. But then eventually the victim feels like they're walking on eggshells. There's tension that's mounting, and it gets to the point where they don't feel safe in their own home or in their environment, in their relationship, and the victim can no longer control the situation. This is typically the longest phase, and it's very volatile. And then, of course, is the explosion. And this can be one incident. It could be many incidents. It could be, something that seems relatively small, and then the whole cycle repeats itself. But it is oftentimes a serious incident of domestic violence, whether it be physical or otherwise. But that through the tension building, the client begins to lose their self-esteem and feel they can't do anything right. And then after an explosion, they may actually feel like it was their fault. Sometimes the abuser will blame the victim and say, if you hadn't done this, then I wouldn't have reacted that way. And because of that lack of self-esteem and because of all of the things that we talked about with the power and control, the victim now feels like, oh, it was my fault. Or even if they don't feel that the blame is on them, they feel that there's nothing they can do because of the power and control that the abuser holds over them. So as you can see, this becomes so problematic. But then after the explosion, if the abuser is there to ask forgiveness, beg for the victim to take him back, then oftentimes the victim is in a place where they want to believe that the abuser is capable of changing, capable of being that knight in shining armor that he was at one point. And especially if there are children involved, the situation becomes more complicated, and oftentimes the victim feels like it's the best thing for the children or others if they stay in the relationship with the hope that things will get better.
So I'm going to talk a little bit about issues in representation, and it's mainly going to focus on attorneys and legal representatives working with clients in these situations. So just to sort of start out with, a big piece of working with an individual who's a survivor of violence has to do with confidentiality, which if you're an attorney, you learned about in professional responsibility. So this is the Model Rule 1.6 regarding confidentiality. And the basics are you can't reveal information that a client reveals to you unless they have specifically consented for you to reveal that information, unless they have implied their consent for that information because it's necessary for you to proceed with representing that client, or with some limited exceptions. So this says if the disclosure is permitted by paragraph B, so we can go into that. It's important to, and we'll go into that in a minute, it's important to keep in mind who your client is in these situations. So in immigration cases, there's often a lot of players. Sometimes we are working with an individual client and her family members. Sometimes we're representing multiple people in a relationship. Those cases of dual representation get a little bit more complicated. But even if we just have an individual client, what we need to keep in mind is our duty of confidentiality is to that person, not necessarily to that person's advocate, to the person's family members. Even if the family members are extremely helpful and very involved, you always want to make sure that the primary person you're keeping in mind as far as your duty of confidentiality and really all of your interactions should be towards this individual client. So you can definitely work with all of these helpful people, and sometimes it's absolutely necessary because the client won't have all the information. If you have a client who is a child, who's extremely traumatized, who doesn't have necessarily access to technology, to all of the information, to all of the documents that are necessary, you will have to depend on a large group of people sometimes in order to effectively represent your client. However, it's important to make sure that your understanding through all of this is not that, well, I called my client's advocate and I told her what was going on and that's enough. It's important to really keep in mind that your communication should always be directed towards that individual client, and that before sharing information that the client tells you with these other individuals, you need to make sure the client is giving her informed consent about where that information will go. So just because the client said it was okay to tell their advocate something doesn't necessarily mean that everything that the client shares with you should then be shared with their advocate or with some other family members. It's also important to explain to the client where the information revealed in her application will go. So for example, in a VAWA application or a U visa application, you are revealing information that this client is sharing with you to the government, and that's for the specific purpose of helping that client obtain immigration relief. But it's also important to make sure that that client knows the limits on how you're sharing that information. So one of the things that you can explain to the client is that that information is subject to some limited confidentiality rules. So Section 384 of IRA from 1996 prohibits DHS employees from providing information about a U visa applicant to third parties. Section 384 prohibits DHS from making decisions about removability based solely on information provided by the abuser. So there are certain statutory and regulatory protections in place for individuals who are applying for relief based on having been victims of abuse. Those are ways in which you may need to advocate for your client, and I'm sure that Tricia could talk a little bit about sort of the parameters of how we see these provisions come into play. But these are the baseline rules, and so these are things that you can use to sort of make your client feel a little bit more comfortable revealing this information. The way that it is supposed to work is that even if you reveal your information to the immigration authorities, they are not supposed to be able to take adverse action or inform your abuser based on what you're revealing. So going back to that model rule on confidentiality, some limits on the duty of confidentiality include, as you may remember from professional responsibility, to prevent reasonably certain death or substantial bodily harm. This is a pretty unusual case, right? Like this is not your typical attorney-client relationship. This is specifically intended for emergencies to prevent very serious consequences. However, it's important to go over them because when we're talking about clients who've been victims of violence in the past, we're also often talking about clients who can be in dangerous situations in the present. So it's important to think about ahead of time how you will react if it's determined that your client is in some sort of emergency situation. So for the most part, our clients are out of immediate danger by the time they're ready to work with an attorney to file their application for relief. However, life happens, things happen, and clients become involved in dangerous situations. An abuser may come back. There may be some new attack. There may be some completely unrelated emergency that puts someone in danger. That's very possible. Again, taking a client-centered approach, it's very important to recognize that if an emergency arises, the client herself is always the one who has the choice to decide how she will respond. I think that's especially important for individuals who've been in abusive relationships and abusive intimate partner relationships. The big thing about being in that relationship is that you've had your choices taken away from you. And so as the attorney working with an individual like that, you want to make sure that your first step is always to allow the client to make the choice, the informed choice about how they want to proceed, and that includes in emergencies. Unless there is an immediate life-threatening emergency, we recommend that you always check with NIJC if you suspect your client is currently in an unsafe situation. We work regularly with individuals who have a wide variety of just different dynamics in their lives, and so we'll be able to provide guidance on what some good steps might be, how to help and support your client without further endangering her, and how to really navigate that situation in an appropriate and also in a safe way. One thing to keep in mind is that involving the authorities in these situations, authorities including the police, including the Department of Children and Family Services, child protection agencies, they can be risky and unpredictable for our clients. And they may be that way in ways that, that you have not experienced personally. Maybe you have. But it's important to recognize that this risk exists. So having the automatic reaction of calling the police may not always be your client's first choice, and it's important to respect that and to acknowledge the other ways in which a client may choose to try to keep themselves safe.
So on that note, I'd like to invite anybody to type in any questions that you might have. We're going to continue with the webinar, but feel free to ask questions if you have some. That first section was really sort of us talking about like the warnings and things to be aware of with dealing with victims of domestic and gender violence, because we truly believe these are unique cases, and you should know going in that clients in this situation have challenges. There is a question here. For our male VAWA clients, have we been able to identify any mental health providers or counseling services specifically geared toward men in the Chicago area? I don't have the information with me right now, but unfortunately, the majority of the mental health providers specific to victims of domestic violence that are nonprofits, the majority of them are primarily geared towards women, but that doesn't mean there's none for men. We definitely have some referrals for men who are victims of domestic violence. There's also referrals for abusers of domestic violence. But sometimes I've had male victims who have had to seek counseling through private services, because sometimes it's more challenging to get in to the nonprofit referrals. So that's a good question. And if you do want those referrals, you can email me. My information, I think, will be at the end of the presentation.
I will say one organization that comes to mind, I know that the YWCA has a pretty expansive sexual assault survivors program, and that's without regard to gender.
Yeah. So this next section, we're going to actually talk about working on one of these cases and things that you should do as you're preparing to meet with the clients and actually preparing the case. So in our pro bono projects, we screen the cases first, and we prepare the clients and the cases before we refer them to the pro bono attorneys. Once you get the case referral packet, the client has already been screened and knows that he or she is eligible for that form of relief. So we would ask that you review the case referral packet thoroughly, the intake notes that are in there and the case file, and familiarize yourself with the case and the relevant country conditions. So country conditions might need to be proven for a particular case, especially if you're working on like an asylum case. It might not be necessary in, say, a U visa or a VAWA case, but it can help you understand the context of where your client is coming from, right? So if you understand their country and a little bit more about their background, that'll give you a little peek into what they might be dealing with. And of course, look at things like who is your client, their name, age, country of origin. And it's always a good idea to try to figure out how to pronounce your client's name before the first meeting. And if you have to ask them, that's okay. I mean, you can ask us first, but it's just nice when the client shows up for that meeting that they feel welcomed and they feel like you've already taken the time to look at their case. So when you get to that first meeting, we recommend that you keep it relaxed and very friendly and inviting for the clients, okay? So keep in mind that many of our clients, before coming to NIJC, have never been downtown or have never been to a corporate office. And so coming to your office, depending on where you're located, could be rather intimidating. And so if you can at least present things in an inviting and welcoming manner, they might be more willing to share their story with you. You know, they are probably very anxious, already knowing that they're going to have to go talk about this traumatic experience in their life and to a complete stranger. So the easier that you can make that for them, the better it'll be for you and for their case. So this is a suggestion. If possible, avoid sitting behind a desk. You know, it makes a client feel more comfortable oftentimes and more welcome if you can sit sort of next to them, or at least without the barrier of a desk between you. Now, in some environments that might not be possible, but it's just something to keep in mind. You want the environment to feel safe and confidential. So you definitely don't want to be meeting with the client in an open area. I know some of our pro bono attorneys who are not with big firms have to find spaces to meet with clients, and that's fine, but keep in mind that you want it to be a safe and confidential environment. So you don't want to meet with them in a restaurant where other people can hear what you're talking about, and we recommend not meeting with them at their home because oftentimes there are other people around, including the client's children or parents who don't necessarily need to hear the details. So that leads to the next point. You should always speak with the client separately from other family members after the initial introductions. So it's fine if the client shows up at your office with, you know, their parents because they're all going to be U-Visa clients, and you introduce yourself to everyone, but then you need to make sure to meet with each client individually and explain confidentiality and explain who the client is and who you're going to be reaching out to regarding communications on the case. Okay, so you want to explain your role, and you want to also empower the client. Okay, they need to understand that this is their case. They are the boss as far as the case is concerned. So the things that Hillary was speaking about, for example, if another incident occurs and the client decides that they do not want to call the police, and they tell you this, and they say, well, what do you think I should do? Remind them they're the boss of their case. You can obviously make recommendations based on how things might affect their legal case, but ultimately this is their life, and they need to understand that they're going to have to live with the consequences of the case, and so they should feel empowered. They should feel a sense of control and authority over their own case. And when you're doing all of this, try to use friendly terminology, right? You want to speak to the client in ways that they will feel comfortable sharing their story with you. So, you know, if they refer to their abuser as my children's father, then maybe refer to him that way too. If you keep calling him the abuser, that might turn the client off, and they might not feel comfortable talking to you about this anymore. You know, similarly, sometimes we're talking about family members. And so we've had cases, for example, where maybe it was the grandfather who committed sexual abuse against the minor child. And that can be tricky when you're dealing with multiple family members. And maybe some people don't want the case to go forward for other reasons. Your duty is to the client, and you need to speak to the client in friendly terms so that they always feel comfortable speaking to you, because they might not have the support of other family members or other people in their community.
I'll also point out regarding friendly terminology that for at least those of us who are attorneys, there is this tendency to regress into jargon. And that is even talking to other attorneys, talking to friends and family, and it's kind of obnoxious, right? Like it is better as a practice as a good attorney to explain legal matters in terms that other individuals can understand. And that is whether or not you're talking to a judge, an opposing counsel, to a client with a lot of education, to a client with a little education. Try to keep that front and center if you're representing someone, to explain the process in terms that they can understand, and to not simply revert to kind of shorthand or jargon that can be alienating for just about anyone.
So the other thing to keep in mind is you need to make sure you have a way to communicate with your clients. So depending on what kind of work you're typically doing, these clients might be very different than the other clients you're used to working with. So, for example, you might be used to doing the majority of your communication by email through work. Some of our clients have never had an email account and don't even have access to a computer or a smartphone. So you have to look at this through a different lens, okay? You need to ask the client, how is the best way for me to communicate with you? Should it be by phone? Should it be by mail? You want to find other friends or family members' contact information that they can give you that you can reach out to if you can't reach the client and you need to quickly, okay? So we usually try to get 2 or 3 phone numbers that we could contact. And of course, you don't have to share confidential information with this other person, but if the client's phone numbers aren't working and you need to reach them, you need to have a way to communicate with them. So getting their employer name can be helpful. Sometimes clients can be reached at work. Keep in mind, too, that oftentimes clients who are dealing with gender-based violence are in situations where they might have to leave their home. And so some of our clients are transient. Sometimes they're not able to answer the phone because it's unsafe to do so. Sometimes they can't answer the phone at work, which is typically when you're going to be working on their case. And sometimes they don't have voicemail. So if you call the client and they don't call you back, that might not be because they're no longer interested in working on their case. Okay, we do run into this sometimes where the pro bono attorneys think, oh, the client must not be interested in the case anymore because I haven't heard back from them. Well, if the client didn't get your message or didn't know that you called, then they're not going to call you back because we usually tell them not to bother you and to wait until they've heard from you. So please establish a way that they can reach you and that you can reach them. And always make sure you have a safe mailing address and make sure it's safe to send mail before doing so. And the same with voicemail messages. Because in some of these relationships, the abuser has access to everything. And it's simply not safe to leave a voicemail message or send mail. And we are sometimes recommending for our clients that they leave their documents with a friend or in a safe deposit box, someplace where the abuser won't have access to that information. So now that you've met with the client and you've sort of established this relationship, one of the most important pieces in the case is going to be the affidavit. Okay, the affidavit for the asylum case, for a U-Visa case, for a VAWA case, a T-Visa case, pretty much all of the cases that we're talking about today is going to be the single most important piece of evidence in the case because it is the applicant's opportunity to share their story. Some of these forms of relief will not involve an interview, and so this might be the only opportunity that the client has to explain what happened in their case. It's also a way for you to, in the client's words, express to immigration sort of this roadmap, okay? We recommend doing it in chronological order where you can establish the background and then the history of abuse and violence, and then of course talk about the client's claim, and that may involve inadmissibility grounds. It of course is going to involve proving the elements of your case, but all of that should go into the client's affidavit, and you really want to use the client's voice. So as Hillary was talking about jargon, you definitely should avoid any legalese in the client's affidavit. I mean, the client's not going to tell you their story that way, so you shouldn't be telling their story that way to immigration. Now, depending on the case and depending on the individual client, it might be helpful for the client to draft an initial affidavit. I find this useful and sometimes therapeutic for the clients, but sometimes that's not going to be possible. I would imagine it's not always possible with children, and some of our clients are illiterate and simply can't put their thoughts into words on paper. So whether or not they draft an initial affidavit, you're going to have to go through it with them, and you're probably going to have to make extensive edits. When you're meeting with the client to work on their affidavit, keep in mind that this is really, really difficult, okay? So talking about the trauma can be traumatizing in and of itself. And for many of our clients, they have blocked out some of these instances of abuse in order to survive. So it's going to be challenging, and they're going to need to take breaks. Some clients are going to give you an initial draft that's 20 pages long and are going to be very willing to talk about it. But some clients, it's going to be like pulling teeth to get them to write 3 paragraphs. So each client is different, each case is different, but it's really important that you acknowledge that this is difficult and that you thank the client for sharing their story with you. Thank them for trusting you to share this information and to put this into paper for them. And then at the end, when you have the affidavit drafted, you do have to go over it with the client to make sure that everything is correct and make sure that they do actually agree with everything that you've put into paper, okay? Because sometimes they need to sit on it and they need to think about it, and that will help them remember other details. And sometimes things will change. Sometimes the client will come back to you and say something that they completely left out, or that it completely contradicts something that they previously told you. So oftentimes the affidavit requires multiple revisions before you have a final product. And we recommend in the meetings to end with some lighter conversation so that they're not leaving your office just thinking about and reliving the trauma that they've experienced, but rather something a little bit more positive, more lighthearted, talking about the weather or what they're going to do over the weekend.
So I'm going to talk a little bit about just some of the effects of trauma, with a caveat that I am not a mental health professional. I'm a lawyer who works with individuals who've experienced trauma. So we will at the end provide some resources from mental health professionals that we really highly recommend to just learn a little bit more about trauma and its effects on the brain and how that can affect your client. But I do want to talk just a little bit about these effects and how they can inform your practice when you're working with a client. So as Tricia mentioned, your client's story is going to change. That is just a fact. People's memories change. That is not necessarily an indicia of lack of credibility. It doesn't necessarily mean that they are lying. All of us have memories and they all change. So that is frequently an indicator of trauma, that there can be gaps in your memory, that things can change with time, that things can change depending on where you are when you remember them. There will also be inconsistencies. Those are important to explore with your client, because if you see an inconsistency, the person reviewing the application will also see it and will have questions about it. But it's important to approach it, at least at first, from the position of how do we explain this? Can you give me more information? As opposed to jump into the conclusion that your client is lying about whatever their experience has been. Another thing to keep in mind is that trauma and violence affect different people in different ways. So you may have a client who gets very emotional every time they talk about what they have experienced, or you may have a client who's just absolutely, completely emotionless and doesn't really express much beyond the straight facts. I've had clients who have almost laughed or giggled when they told me about very difficult things that they've experienced, and that seems odd, but that does not mean that it is not a thing that they have experienced. That is actually a reaction to trauma. Inappropriate affect is one thing that trauma can cause in those who've survived trauma. So all of this to say, it's just important to keep in mind the different ways that people can be affected. Mainly for your purposes, it's to allow you to have sympathy and insight into why a client may be acting a certain way. And these don't necessarily mean that they are credibility issues. So working with interpreters is a big one for our pro bono attorneys and other individuals who work with immigrants, because quite often the applicant themselves does not necessarily speak English fluently. So if you're going to work with an interpreter, it's very important to establish the ground rules before you get into the meeting with your client. If possible, meet with the interpreter individually before you meet with your client, even if it's just for 5 minutes to go over what your expectations are. Make sure that this is a person who's going to be able to help you understand the survivor's voice. Definitely make sure the interpreter understands confidentiality. So the volunteer interpreters that we use at NIJC have been trained, and they understand and have agreed to keep confidential all of this information. If you're using an outside interpreter, you need to make sure that they understand that they are not allowed to reveal any of this information. And then other expectations about working with an interpreter include you want to make sure there's no side conversations between the client and the interpreter. You also want to make sure you're not having side conversations with the interpreter in front of the client, because that can be alienating. Make sure that the interpreter understands that they need to be interpreting word for word what is said. It's a challenging job to interpret, because word for word interpretation doesn't always work in every context. But it is really important for you to hear everything that is being said in order to really understand the way that it's being said, so that the interpreter is not summarizing and putting their own understanding on what this individual is telling you. Just as a best practice, when you are speaking with a client through an interpreter, you should still be speaking to the client. You should be saying, what happened to you? How do you feel? As opposed to saying, can you please tell her that X, or can you please ask her Y? That is just a way to make sure and make clear that the direct relationship is between you and the client, and not between you and the interpreter. In addition, if the client has questions, make sure that the interpreter knows that you will need to be the one to answer those questions, so that there is no issue of whether the interpreter is providing advice or answering questions separately from you. Just once again, your role as the attorney here. It's important to keep in mind that you may be one of the only stable people in this client's life, right? We have many clients who have excellent support systems, and that's great. And we also have many clients who just really lack a lot of support, whether that's financial, emotional, housing support, physical support. All of those things may not be there. And so it's important to balance your role as the attorney, right? You are not the client's therapist. You're not their best friend. But you have access to resources that they don't have. And so if you see a need that the client has and you're curious about how they might be able to connect to resources to fulfill that need, definitely reach out to NIJC and see if we have some referrals for you. So NIJC works with a lot of different organizations that can provide counseling, that can help clients access housing, all of those things that a client may need in order to have a functional legal case, but that you may not have be able to personally provide. And then finally, the big thing about working with individuals who've survived violence is your primary position should be of listening without judgment. You will eventually be making an analysis of your opinions of this case, but you want to keep an open mind while you're listening to the client. And then last of all, it is important, given all of this work that you are doing and all of these experiences that you're hearing about, to keep in mind self-care, right? Those of us who've worked in this field for a long time can attest that it's difficult, right? Secondary trauma is a real thing. Secondary trauma means even if you haven't personally experienced a trauma, if you hear about it day in and day out, over and over, it can be grinding. It can grind you down. And so it's important to take care of yourself in order to be able to take care of other people. That can mean establishing boundaries as far as times that you're available, things that you're able to do, and then also just looking for the things that make you feel good. So seeking support with family members, therapists, exercise, all of those things are good ways to take care of yourself so that you can continue to do this work, and we want you to be able to continue to do this work. So there's all kinds of reasons that this is challenging. It's very fulfilling work. But it also requires a big commitment both to the client and to yourself in order to keep yourself in the kind of shape that you need to be in to do this work effectively and compassionately. So finally, we have some reference sources and contact information for other resources that you may want to look into. So these are just sources of law on the issues that we're talking about. And these slides will be saved on our website, I believe, so that you can check these out later on. There's also just more social resources. So there's a domestic violence helpline for Vermont Service Center inquiries, the immigration courts line, and then there's some additional resources on trauma, like we mentioned. So we want to thank you for attending the webinar. Again, if you have any questions after the webinar, our contact information is here. And we appreciate all the work that you do on behalf of our clients.
Thank you.